Yeah, so hello everyone, and thanks again for the first two presentations in this panel, which I think were really great. So it's a bit of a stretch from what we've just heard to what I'm going to talk about now, and I apologize for that. But I'm going to talk about animals and consent. Let me first say a few words about the background and aim of this project. So I first started working on this question when I was a visiting researcher or visitor at the Cambridge Center for Animal Rights Law in spring last year. And my idea was that I wanted to do some legal research, but on a project that moves beyond the question of the legal status of animals and instead focuses on the relationships and interactions that we have with them. And I'm wondering mostly about these relationships and interactions in the future. So in a future where we have reached some consensus that animal rights should be respected. I think in that future we need new legal concepts to govern our interactions and relationships with animals. And more precisely, I was wondering whether consent or a concept related to consent can perform that function to navigate our interactions with other animals. Now this sounds quite abstract, so let me break it down to some examples. Here are some situations where consent could matter. What if an animal resists an important medical procedure and refuses to agree to submitting to that procedure? What if she enjoys labor that is dangerous for her, like policing or rescue? Or what if she enjoys enthusiasm, if she shows enthusiasm about participating in some, let's say, behavioral research that might not really impose harm on her, but still prevent her from living a more joyful life outside? Just think about these situations maybe for a moment and think about intuitively what you would do about them and why. Meanwhile, here's what I want to do with you today. First, I will consider whether animals can give consent. Answering that question in the negative, I will consider alternatives to consent, zooming in on the assent and dissent model. I'm not convinced by that either, and this is why I will show you some risks of applying consent-related concepts to animals and propose a different possible way forward before drawing some conclusions. Now, first, the question, can animals give consent? To answer that question, let's first remind ourselves what consent actually is and does. Consent is really crucial in the law because it makes a difference between a violation of a fundamental right, such as, for example, bodily integrity, and, for example, a routine medical procedure. So when I go to donate blood, this is an example of where I give consent. If I agree to having my blood taken and the nurse takes my blood, no violation of my rights, everything is fine. If I do not consent and someone takes my blood to donate it, that's a problem, it's a violation of my rights. Now with that in mind, there has been some controversy about whether animals can give consent. Some authors are maybe now tending to explore this, and maybe some people are already saying that animals can give some form of consent, but other authors have also identified problems with that. Quite common is the objection that animals cannot give consent in interactions with humans because we are lacking a shared language. Others say that the problem is with informed consent. So for consent to be valid, one has to be informed about the relevant information. And animals can never give informed consent in that sense because they're lacking the capacity to understand the reasons for why we're asking them to do certain things or permitting certain things. But I think, and here I'm drawing on Richard Healy and Angie Pepper, the problem goes even deeper than that. The problem is with consent itself. It is that animals lack the capacity to form complex intentions that are necessary to waive a right. So what do they mean by that? In order to waive a right, one first needs to be aware that one even has a right in order to make that crucial decision to waive it in a given situation. And this is why I think it is fair to conclude, or let's, for the purpose of my argument, conclude for now, that animals cannot give consent in the same way as humans do, and as human law assumes that we can. Now, this being said, some authors have lately proposed alternatives to consent in that human sense. The idea is that a consent-related concept, although it would not be identical with human consent, could have the same consequences as consent. That means an animal could communicate that she is sufficiently disposed toward a certain activity, that engaging in that activity would not violate her rights. This kind of thinking has gone under different terms, often under the term of assent, factual consent, or embodied consent. You find the relevant references for that at the end of the presentation if you're interested. But what all of these concepts have in common is that they're based on the idea that animals have an interest in self-determination, and that needs to be somehow reflected. So what I want to do now, because I find this idea very, very intriguing, is to see whether we can carve up some conceptual space for this kind of thinking in animal rights law. And again, I'm not talking about applying this to factory farming as we're seeing it now. I'm talking about a future where we have transitioned away from that. And to highlight a bit better what these concepts that are alternatives to consent could mean, I want to briefly explain the assent and dissent model, mostly as it was developed by Richard Healy and Angie Pepper, because it is really comprehensive and compelling, I think. They define assent as the willful affirmation of an act, which can be communicated non-linguistically. So the problem of the shared language could be overcome in that sense. For assent to be morally transformative, they say that an animal must assent voluntarily. That means she must be given the opportunity to dissent, and she must do that with sufficient understanding. Richard Healy and Angie Pepper also say that the expressed preferences of an animal can sometimes be overruled, and that is if an animal does not understand the relevant information. So clearly this is particularly important in medical contexts, such as animals being vaccinated against a dangerous virus. Now, Healy and Pepper mostly think about interactions with companion animals, one-off interactions in these small contexts. So you could think a dog waiting at the gate with a ball is assenting to going outside for a walk and to playing. But assent-dissent models have also been suggested in other contexts, most importantly in the context of research involving animals. And I think this is quite different, and it leads me to my next point, where I want to highlight some concerns. I think that assent and related concepts are really promising in the micro contexts that Healy and Pepper mostly draw on. So that would be mostly companion animals. But I think as legal scholars, our task might be slightly different, because we have to think about whether these concepts can also inform the future of the law specifically. And here is where my concerns apply. The first I call the human interlocutor. So remember I said that animal assent is supposed to make room for animal self-determination, for an animal's subjective will, rather than that of a human person like a guardian. But let's not forget that even then humans would still play a really crucial role. It would still be up to humans to interpret animals' expressions and to decide whether their subjective will can be decisive in a given case or not, whether animals do possess the relevant information in the specific case. And this is problematic not just because, again, humans are in the position of actually determining a lot of the decisions at stake, but also because I think there's a wide sense of agreement that humans interpreting animals' expressions are quite likely to be wrong, because we simply do not have the sufficient understanding and the shared means of communication to figure these things out. Now, one can object that that problem can be mitigated. We can maybe learn more, we can try better, and there are some references for that as well if you're interested. But the point that I want to make is that if assent or a related concept is to have these same far-reaching consequences as consent, can we really risk this vast opportunity of misinterpretation here? Another concern that I have is that consent-related concepts could gloss over persisting power imbalances between humans and animals. So it's always humans who decide which animals are involved in certain activities. And again, I'm using the example of research here because I think this is just a striking example where the stakes are quite high. I'm concerned that humans would be likely to use animals that are less able to communicate dissent in a way that we understand, for example, mice, or particularly docile breeds like beagle dogs, instead of maybe drawing on other criteria that would have to be applied to decide which animal should be chosen for research. I also have some concerns about genetically modified animals and the selective breeding. And again, I don't want to go into the ethics of these practices as such. Rather, my point is that if we base a lot of weight on animal assent, we would attach the consequences of consent to preferences and expressions of preferences in animals that we as humans have created. And that, I think, is something we need to think about. Another, perhaps the most striking example of such persisting power balances could manifest in what Martha Nussbaum, amongst others, has called adaptive preferences. Adaptive preferences is a phenomenon where individuals adjust their preferences to the options that seem achievable to them or to the way of life they know, without really being aware or in control of this process. That means that individuals who have been subjected to unjust treatment for a long time might not recognize this treatment as unjust. And now in the human case, where adaptive preferences are seen, for example, in women who have been subject to violence in a domestic context for many years, we all agree, basically, that adaptive preferences do not prevent that individual from giving consent later on, for example. Or even in the situation itself, consent is still legally an option. So even if our subjective preferences are shaped, for example, by prior injustice, humans are considered, in most cases, capable to reflect upon the options that are available to them and measure these options against what they believe is due to them as a matter of justice. And I think that most animals, most likely, do not have the capacity to do precisely that, to think of themselves as having rights and being owed a certain treatment as a matter of justice. So even when we present animals with certain choices, we need to be aware that those choices are pre-chosen by us, and that animals will rarely reject a certain treatment, not on the basis that they have seen, for example, other animals getting better treatment, but on the basis that they would be owed something completely different, simply on the basis of rights and justice. And now, just very briefly, I think there is also a legal problem when we try to bring animal assent into the law. And that has to do with generality. I mean generality here as a formal requirement of the rule of law that basically, to simplify a lot, means that legal norms must be universalizable. It means that certain individuals cannot be targeted by or excluded from a given norm just because we find the outcome undesirable in these cases. So if we apply assent or dissent to interactions with companion animals, then I don't really see, based on generality, why exactly we do not apply to farmed animals or animals used for research. What else than our knowing that this would lead to undesirable outcomes prevents that? And so overall, I think this feeds into my criticism that there is a risk of legitimizing animal use that we should critically question, for example, research involving animals. So situations in which animal assent is to be considered decisive are not the general rule, but perhaps rather the exception from the rule. And I think this is something we can work with if we want to bring animal assent into the law, not as the rule, but as an important exception. And this is why I briefly want to outline a possible way forward. And I haven't thought that much about this yet, but here's what I'm thinking so far. And this connects quite well to a discussion we had in an earlier session today. We talked about that there under the headline of animal autonomy. I'm talking about it under the headline of self-determination, but I think some of the arguments we exchanged might still apply. So remember that I said that the suggestion to include animal assent in our interactions with animals is grounded in the idea that we need to respect animal self-determination. And I think we can maybe take a differentiated approach to that. While some people might submit that animals have none or almost none intrinsic interest in animal self-determination, I'm ready for the purpose of the argument to say that they have some interest in it, although I'm not sure where I stand on that. But let's assume for now that if animals have an interest in self-determination, it is still, in most cases, A, limited. That is because most animals have less capacity of long-term planning and self-reflection. And that is something that Richard Healy and Angie Pepper also point out in their paper. But it is B, also restricted by the fact that we as humans will always determine the structures and the contexts in which we interact with animals, including and especially the law. So what do we make of that? I think we should take away from that well, we should keep in mind that paternalism is always present in human-animal relationships. And it is also less problematic than it is between humans due to the less weighty interest of animals in self-determination. And related to that, I think we should keep in mind that when we talk about animal rights, we usually ground that in an interest theory of rights. And this is something that we should also keep in mind when we talk about the rules governing our interactions with animals. Because if we place too much weight on the subjective preferences that animals express, we tend to go away from that interest theory of rights and focus more on autonomy, and maybe also on autonomy as the basis of rights, which is maybe something that where we don't want to go, because it would actually be contrary to a lot of the other work that already has been done on animal rights. Secondly, I think we don't need to do away with guardianship altogether to allow for more animal agency. Rather, maybe we can think about a guardianship model that takes animals' interests and subjective preferences into account. A guardian's decision could be primarily based on an animal's best interest rather than herd assent. And assent could still matter because it includes, of course, information about an animal's interests. So if an animal assents or dissents, she gives us important information about what's good for her. And to that extent, it can matter. And here comes again what I earlier said about rules and exceptions. Guardian consent for the animal could be the norm, with procedural safeguards in place to consider animal assent and dissent in the decision-making process. And animal assent itself might also be decisive in some cases as an exception from the rule in defined microcontexts. And I think the upshot of this idea is that under this concept, for example, research that deprives animals of a more joyful life or work that involves serious risks for them cannot be justified by their assent. And I also want to stress again that in this way forward, the legal lens is essential because it just highlights a lot of the things that I was trying to say. So if a decision is exceptionally justified by assent rather than by an animal's best interest, which we would define objectively, the guardian of the animal who claims that assent is decisive in this case must prove it and explain herself for that, which provides an additional safeguard. And I'm also open to saying that as our society changes and animal rights become a reality, and further a reality, we can gradually enlarge pockets of animal decision-making within the law by revising these laws and seeing in which areas animals are actually capable of making decisions because we haven't interfered as much for long enough. And even then, I think we have to draw limits where the principles of law and lawmaking that refer to concepts like rights and justice are concerned. And of course, we also have to rethink what these phrases mean when animals are concerned, but that is a question for another day. So these are maybe the main takeaway points from what I just said. I think there is some space for assent and dissent and other consent-related concepts in animal rights law, but that space is limited. I think we should incorporate the insights from an assent-dissent model within a revised guardianship model, rather than starting over. And the crucial argument for that is that humans determine and will always determine the contexts in which our interactions with other animals take place. And that is not to say that animals don't need legal protection. It's quite the opposite. I'm not saying that animal assent shouldn't count because I don't want to support animal rights. It's quite the opposite. We need to be cautious with animal assent in order to protect animals' interests. And the limited level of paternalism that is inherent in a guardianship model, I believe, is unavoidable. And it is less harmful than in the human case, given animals' very limited capacity for self-determination. So guardians must base their decisions for animals based on their best interest while taking the subjective preferences into account. And finally, again, this is open to the possibility of gradually enlarging the scenarios in which animal assent can play a role. And here are references from the slides if you're interested. Thank you.